Good afternoon, everyone, and welcome to today's webinar, Judicial Trends, Recent Case Decisions with Long-Term Implications for Public Health, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. I'm Charles Strong, the Senior Digital Marketing Coordinator at the Network's National Office, and I'll be your host for today's webinar. Next slide, please. We strongly encourage attendee participation, so feel free to submit questions at any time during this webinar by using the Q&A button on the bottom of your screen. All you need to do is click on that button and send us your question. We'll be addressing them towards the end of today's session. Next slide, please. Your moderator for today's webinar is Morgan Jones-Axtell, a staff attorney with the network's Eastern Region office, and she'll be leading us through the rest of today's webinar. So Morgan, over to you.
Thanks, Charles. Hello, everyone. Thank you so much for joining us here today. Good afternoon or good morning, depending where you're chiming in. I am very excited about today's webinar on recent judicial trends in public health. So we will be covering some important topics today, such as vaccine mandates, reproductive justice, federal and state public health authority, cannabis, access to healthcare and medication, voting rights, and possibly gun control if we get there. So I am happy to introduce our two fantastic speakers, Jen Pyatt and Kathy Hoke. Jen is the Deputy Director of the network's Western Region office, as well as a research scholar with the Center for Public Health Law and Policy at the Sandra Day O'Connor College of Law. Her work is concentrated in the areas of emergency public health legal preparedness, crisis standards of care, and vaccine mandates. Kathy is the director of the network's Eastern Region. She also directs the Legal Resource Center for Public Health Policy and is a professor of law at the University of Maryland Carey School of Law, where she teaches public health and the law, directs the Public Health Law Clinic. Kathy graduated from the University of Maryland Carey School of Law, clerked on the Maryland Court of Appeals, has worked in private practice, and then spent almost a decade as an assistant attorney general in Maryland. Kathy's work has focused on tobacco and alcohol regulation, injury prevention, and environmental health, with a keen focus on health inequities. And just a quick reminder to put any questions you have during the presentation in the chat, and I look forward to the Q&A near the end of the webinar. I will hand it off to Jen and Kathy. Thank you.
Thank you so much, Morgan, and good afternoon, everyone. Thank you so much for joining us as we come to you live from opposite ends of the country. I'm coming to you from Arizona, Kathy is coming to you from Maryland, and today we are going to discuss some recent updates in our network newsletter, Judicial Trends in Public Health Law. Next slide, please. So this is a monthly newsletter, comes out around the 15th of every month. And our aim with JTPH is to monitor relevant court cases and trends in those cases in the areas of public health law. Next slide, please, Kathy. So you can subscribe to the JTPH newsletter via the network's website and get those monthly or occasional blasts if a hot case comes right off the presses. Our next edition is forthcoming on November 15th. And we also have links to case archives on the network website. The 2019 to 2020 archive contains over 200 cases across a vast number of key public health related topic areas. Next slide. So let's take a quick look at some of those topic areas. We vary our cases based on 10 key topic areas, and those are on the slide before you. They are broad, they are vast. All of them are affecting public health law as we speak. The source and scope of legal powers, chronic conditions, communicable conditions, and as of late, constitutional rights in the public's health and public health emergency preparedness and response have really been key areas over the COVID-19 pandemic. Next slide. So I am thrilled to start off with a topic that has been at top of mind for the past 10 months or so, and that's vaccinations. But before we turn to specific COVID-19 cases, I wanted to take a look at some developments in the vaccine space more generally. First, let's take a look at an 8th Circuit Federal Court of Appeals decision, BWC versus Williams. Now, in this case, parents of Missouri public school children sued, arguing that the state's required form to get a religious exemption from mandatory vaccination was unconstitutional. Specifically, the parents argued that the form violated free exercise and equal protection guarantees in the First and 14th Amendments of the US Constitution. Parents objected particularly to a statement on the form that advised that parents vaccinate their kids. The 8th Circuit agreed with the trial court and found that the form neither required signers to support that statement nor act in any way contrary to their religious beliefs. What the court also found with respect to equal protection is that the form had been neutrally drafted and did not unfairly target religious individuals. Now, later on this same year, the Arkansas Supreme Court addressed parental rights with respect to vaccination of children in Macklin versus Arkansas's Department of Human Services. After a lower court denied a mother's request to prevent the ADHS from immunizing her daughter over the mother's objection, she appealed. ADHS was at that point in time the temporary custodian of the child, but the mother argued that ADHS could not vaccinate the child over the mother's religious or philosophical objections. And the Arkansas Supreme Court here actually deferred to language in Arkansas law to the Arkansas General Assembly, which had established public policy and essentially acknowledged that the state's interest in promoting the health and safety of its children must yield to the rights of parents to make fundamental decisions in the lives of their offspring. So what do these cases illustrate? Well, these cases illustrate that there is continued and ongoing litigation surrounding vaccination, even outside of the COVID-19 context. It's really easy to focus in on that in recent months, but particularly this litigation continues in the areas of religious freedom and of parental rights. And we'll talk a bit more about religious freedom in a moment. But first, let's turn to some COVID-19 specific cases. Next slide, please. So this first case concerns private industry challenging a state law prohibiting proof of COVID-19 vaccination, or what may be referred to in news reports and has been referred to as sort of COVID-19 passports. In Norwegian Cruise Lines versus Rivkeys, a Florida federal court actually temporarily halted application of a Florida law banning COVID-19 passports. So in this case, Norwegian Cruise Lines had been planning to resume passenger cruises after 15 months of suspended services due to the COVID-19 pandemic. And they were going to require all passengers to provide documentation of COVID-19 vaccination prior to boarding as a safety measure. But Norwegian argued that the Florida law, which banned essentially requiring this documentation, operated as an impermissible restriction of the freedom of speech under the First Amendment, and also was an unjustified restriction of interstate commerce, which is actually an area where the federal government controls and not state governments. The court agreed. The court agreed with Norwegian Cruise Lines and found that they were likely to win on their claims that the law impermissibly restricted free speech and violated that split of federal state authority by imposing significant burdens on interstate commerce that would drastically impact the plaintiff's ability to operate cruise lines. Now, this case on its own can help illustrate the potential alignment of private industry with public health in the event that state policy does not conform to public health guidance. Next slide, please. Now let's move on to COVID-19 vaccine mandate decisions. These are two of the biggest decisions that were issued early on, but this litigation continues, and it continues in a big way beyond just these two cases. The first case we saw, Bridges versus Houston Methodist Hospital, this involved an employee vaccine mandate. A federal court actually in Texas rejected arguments by a Texas hospital employee that the hospital's COVID-19 employee vaccination mandate was unlawful. Now, the employees were arguing that the mandate constituted wrongful termination, but the judge said Texas law only protects employees against termination for refusing to commit a criminal act, and receiving the COVID-19 vaccine is not a criminal act. Additionally, the hospital didn't coerce the employees into receiving the vaccine. Employees could still choose to refuse vaccination, but that choice would come with consequences. And further, another argument hinged on language in the Federal Food, Drug, and Cosmetic Act, highlighting individuals' option to refuse an emergency use authorized product. But this language sets standards for the Secretary of HHS. It does not prevent employer-based mandates. And that analysis was actually later confirmed in a Department of Justice Office of Legal Counsel decision, opinion letter that was issued at the end of July. Now, another decision was issued shortly after Bridges in the area of university vaccine mandates. And this is called Klassen versus the trustees of Indiana University. In this case, a 3-judge panel of the 7th Circuit Court of Appeals denied Indiana University students' request to block a school policy requiring all students, faculty, and staff to receive COVID-19 vaccinations before coming back to school. The policy also allowed for religious or medical exemptions, but required those exempt persons to wear masks and be tested twice weekly. And students claimed that this policy violated their rights under the 14th Amendment. But the 7th Circuit relied on a US Supreme Court decision from 1905 called Jacobson versus Massachusetts, which upheld a state's authority to enforce a smallpox vaccine mandate. And so the 7th Circuit used that case and upheld Indiana University's policy, even saying that this case was easier than Jacobson, because in Jacobson, there were no exemptions and the vaccination requirement applied to the entire adult population in the area. Here, students could seek that exemption or they could withdraw from the university. And these cases help to demonstrate that mandatory vaccination, as affirmed in that 1905 Jacobson versus Massachusetts case, is continuing to be upheld against a variety of arguments challenging different mandates across the country. The area that may continue to be the most contentious is the area of religious exemptions. We've seen some sort of differing opinions on this out of the 6th Circuit, 2nd Circuit, and 1st Circuit. The Supreme Court may eventually choose to take up one of those cases. It has not done so yet. At this point, the Supreme Court has chosen to stay out of the fray. Now, with all that information on vaccines, I'd like to turn things over to Kathy to take us through some key cases in another highly publicized topic area of late.
Thanks, Jen, so much. And so, yes, Jen and I had the pleasure of covering cases that hopefully you all have been hearing about in your real life. So the first case that you're going to see on the screen is United States versus Texas. The background here being that this revolves around a Texas statute, often referred to as SB 8, that prohibits abortion if a fetal heartbeat has been detected. And this includes no exceptions for rape or fetal abnormalities. I want to point out also the uniqueness of the Texas law in that it allows, it is not a criminal law. It doesn't allow the state to enforce the law, but rather it allows anyone to bring a civil case against someone who performs abortion or someone who aids and abets someone in obtaining abortion. So if you were to drive your sister to an abortion care facility, you might actually be liable under this statute. And so and there's also provisions in the statute that attempt to deprive courts of jurisdiction of hearing a constitutional challenge to the case. So the United States versus Texas actually isn't the first case you would have heard about. Whole Woman's Health versus Jackson was actually heard in September and is still pending. That was an abortion provider filing suit challenging this law. And you may have heard that went up to the Supreme Court for a preliminary order about whether the statute should be allowed to remain in effect while the case went to trial or not. And the Supreme Court backed off and said, we're not touching this. The procedural stuff in this case, that unique stuff that I told you about, is too complex. We're not going to get involved. And so the Texas law was allowed to remain in effect under that September ruling. Subsequently, the United States actually brought suit against the state of Texas to preserve and protect the right of pregnant people to access abortion pursuant to Roe versus Wade, the existing law in this country. So that's the case that you see on your screen. In early October, the U.S. District Court for the Western District of Texas heard this case and said, while we're going to resolve whether this statute is constitutional, we're going to prevent enforcement of the law. And so for an 8-day window, the law was listed in its effectiveness. But you can see here that the Fifth Circuit Court of Appeals on an emergency appeal by the state reversed the federal trial court and said, nope, this law can remain in effect while the case proceeds. So what's the status now? Well, we're now in a status where immediately the Department of Justice went to the Supreme Court for an emergency petition, again, to stop effectiveness and enforcement of this statute pending while the case proceeds through a trial, right? So this is, again, a temporary an emergency measure that they're seeking from the Supreme Court. If I had any idea how the Supreme Court was going to rule in this case, I would let you know. So don't ask that question during the Q&A because I don't have a crystal ball. But if you're wondering, well, what is going on with the Supreme Court? Why did they back away from the first opportunity in this case? Why haven't, it's been now almost a week, why haven't they ruled on this emergency petition? And I think in large part it has to do with the case that you now see on your screen, Dobbs versus Jackson Women's Health Organization. This is a full case. This isn't an emergency case, not a preliminary case, but rather this case has been heard on the merits and is now before the court because they granted certiorari to hear the case. And they will actually hear oral arguments in the case on December 1st. And because we're now finally in the modern era, you can actually listen to the proceedings live. But this involves a Mississippi case or a Mississippi statute that prohibits abortions after 15 weeks of gestational age. So we call that a pre-viability ban. The Supreme Court has not considered a pre-viability ban since deciding Roe versus Wade in 1973, which by my math is 48 years ago. And so this case really presents, I think, to the court the opportunity, if they want, to reverse Roe versus Wade or make significant incursions into that constitutional jurisprudence. The underlying case was actually favorable to the abortion providers in that the federal district court, as well as the Fifth Circuit Court of Appeals, the one I mentioned that reversed the trial court previously, in this case, the Fifth Circuit actually found the statute to be unconstitutional. And that is the stature in which we find a case before the Supreme Court. I just want to mention that often the Supreme Court hears cases when there are conflicts between circuits, but in this case, we actually have the Fifth Circuit that found a pre-viability ban unconstitutional. There's a case out of the Eighth Circuit that was, the opinion was issued in June of this year involving a Missouri law that was a pre-viability ban. And there, the Eighth Circuit struck that down as unconstitutional under existing jurisprudence. And then in September, the Sixth Circuit, in considering a pre-viability ban in Tennessee law, also struck that down as unconstitutional. So there wasn't a circuit split that brought this case to the Supreme Court. And so for folks who work in reproductive justice and reproductive rights space are naturally and reasonably very concerned about what the Supreme Court might do with our longstanding reproductive rights jurisdiction. One final note, I want to mention that the earlier case that I mentioned, US versus Texas, concerns whether, at this phase, concerns whether the Texas statute is allowed to remain in effect while the case goes through trial. There are significant long-term and short-term implications to SB 8 allowing or remaining in effect during the trial. From a short term, it's obvious, right? There are pregnant people who are not going to have access to safe abortion care. They may have access to unsafe abortion care, and they may spend a tremendous amount of money, going outside of their jurisdiction to seek abortion care. So there are short-term effects. Long-term, what we know historically in these circumstances is that there may be abortion providers that have to shut their doors in Texas because they're no longer permitted to perform abortions past, fetal heartbeat. And even if the law is overturned months, years from now, they may not be able to come back into business. So there are often long-term implications to that short-term decision. So stay tuned. The network will surely let you know when and if the Supreme Court rules on that emergency petition in US versus Texas. just to touch on, again, to give you a flavor of where the Supreme Court is in reproductive justice, this case proceeded in January, where there was a FDA rule, a Food and Drug Administration rule, that said if you were going to use prescription medication, mifepristone, to induce abortion, that can be done in the first 10 weeks of a pregnancy. The pregnant person has to come into a healthcare provider, to a hospital or to a clinic, to actually get access to that medication. They then actually take it back home or wherever their safe place is to be able to administer the drug to themselves, but they have to physically come in and pick it up. During the pandemic, obviously coming in any place and physically picking up was difficult. There were places, many places were shut down. Patients couldn't even have access. And so both the Federal District Court and the Fourth Circuit Court of Appeals said during the pandemic, that in-person pickup rule was an undue burden of violating pregnant people's right to abortion. And so, just to highlight where the Supreme Court is on this, despite the Fourth Circuit saying, no, that rule can't stay in effect, the Supreme Court got engaged in what's called the shadow docket, that emergency, phase, and said, nope, the FDA can continue to enforce that in-person pickup requirement during the pandemic. You can see the date of that decision, January 12th, just before the Biden administration took over. And so the kind of good news is that the Biden administration immediately suspended that rule administratively, and we actually expect them to permanently remove that rule requiring in-person pickup in the short term, hopefully by the end of this month. So those are cases we know the Supreme Court has either been asked to engage in or has engaged in. Here's another one that we might see coming up. And these are, there are two cases right now that create that circuit split that I told you about. The first is a case out of the Sixth Circuit where the court actually refused to block implementation of an Ohio statute that makes the crime for a doctor to perform an abortion if they are aware, they know that the pregnant person is seeking the abortion because the fetus has Down syndrome. And so it doesn't prevent a patient from accessing abortion because the fetus has Down syndrome. It prevents the physician from performing the abortion if they know that. So right now that law remains in effect in Ohio. And then we can see a very similar law that was passed in Arkansas, and a different result out of the Eighth Circuit Court of Appeals there, where they did issue an order preventing enforcement of that law. So again, a very similar law. And so we have that circuit split that I talked to you about. Now in Little Rock versus Rutledge, that case, there is a petition for certiorari, meaning a request that the Supreme Court actually hear this case. And so we'll see. I know it has been distributed to the justices for consideration. And so again, the network will keep you posted, but this may be the next kind of iteration of laws trying to eat away at the protections for pregnant people seeking abortion. The argument here being this has nothing to do with a pregnant person's right to abortion. It has to do with what a doctor may not do. Yes, it's a convoluted argument, but it may have some legal appeal to a Supreme Court that is looking to really, I think, reduce reproductive rights in our country. And then lastly, for my reproductive justice cases is Planned Parenthood of the Heartland versus Reynolds. This is a state Supreme Court in Iowa that upheld an Iowa statute that said where Iowa is receiving federal education grant funds in kind of reproductive education, particularly focused on preventing teen pregnancies, the state was permitted to exclude from those funding opportunities any organizations or entities that provide abortion care. And so that statute was upheld. And then kind of the flip side is in New York. New York passed a statute that was recently upheld that prohibits employers from taking negative employment action or discriminating against employees because of their reproductive health decisions, which includes whether they're using or any type of birth control and whether they obtain an abortion. And so on a variety of reasons, the court upheld that New York statute. It is now sitting in the U.S. Court of Appeals for the Second Circuit. So once again, the network will keep you posted as that case moves through the circuit. So on that note, I'm going to now turn it back to Jen.
Thanks, Kathy. There is a lot to watch for in the reproductive freedoms arena, out of the Supreme Court, out of other courts, for sure. But I'm going to turn now to some trends and recent decisions that we've seen in the area of federal and state public health powers. And a lot of this litigation has come to fruition from actions taken during the COVID-19 pandemic. Now, at the federal level, first, let's talk about the CDC. CDC has come up against some serious roadblocks in recent months. In the state of Florida versus Becerra, a Florida federal court prevented enforcement of the CDC's conditional sailing order. Now, this was issued in October 2020, and the purpose was to safely reopen the cruising industry under a framework. And among other arguments, Florida actually argued that the order exceeded CDC's statutory and regulatory authority, and that CDC failed to consider the prevalence of vaccination rates, the success of COVID mitigation measures, the success of foreign cruise lines in reopening, and less restrictive alternatives. And the federal district court here actually agreed and found that Florida was highly likely to succeed in its argument that the order exceeded CDC's statutory authority. The court discussed the significant threat of injury to the state's revenue and to the economy in the face of continued restrictions, and held that the balance of harm and the public interest favor Florida. Another blow to CDC's authority was actually dealt by the Supreme Court in Alabama Association of Realtors versus the Department of Health and Human Services. And in this decision, the US Supreme Court blocked extension of CDC's COVID-19 eviction moratorium. At the point that it was blocked, it was set to expire on October 3rd. It was blocked on August 26th. The policy was first implemented, though, all the way back in September of 2020 to prevent homelessness and crowded living conditions that helped to facilitate the spread of COVID-19. And it was extended and then extended again. On August 3rd, CDC issued again a modified policy to last through that October deadline to apply only in high transmission areas. But realtor associations and landlords sued to block that extension. The Supreme Court ruled that CDC had clearly exceeded its authority under the Public Health Service Act here. But in a strong dissent, Justices Kagan, Sotomayor, and Breyer argued it was far from clear that the CDC lacks this kind of authority, as the act, the Public Health Service Act, permits CDC to adopt significant public health measures like quarantines, which impose even greater restrictions on personal rights and on state powers than a moratorium does. So these cases jointly may indicate that agency authority may be cabined a bit more strictly in the future by courts searching for very specific authorizing legislative language. Next slide. Now on the state front, this is a different kind of an outcome. Many states have taken in recent months, particularly in the prior legislative session, to legislating policy which is actually contrary to public health or which limits public health powers. And there have arisen sort of varied and interesting arguments to challenge these policies. For example, in my home state, in the case of Arizona School Boards Association versus Arizona, several plaintiffs, including nonprofit educational organizations, sued the state. And this is because of 4 recently passed budget reconciliation bills. They allege that these actually violated Arizona constitutional provisions. So not provisions in the federal constitution, but specifically contained within the Arizona Constitution. And these provisions are called the single subject rule and the title rule. The single subject rule generally requires that Arizona legislative bills have to encompass only one single subject, and the title rule requires that the title of a bill give notice of its contents. But these bills that were challenged were passed as budget reconciliation bills, and they were titled as budget reconciliation bills. But they also contained substantive public health policies to limit schools' abilities to implement mask mandates and other COVID-19 public health measures. So Arizona's Superior Court on August 27th found the bills unconstitutional under that single subject rule and under that title rule in the Arizona Constitution. The state filed an appeal on September 28th, but the Superior Court's ruling currently remains in effect. So what we can see from this and other cases across the country that are going on as well right now is that arguments based in state and federal law and state and federal constitutional provisions are continuing across the country to challenge these public health denialist policies. And we are certainly continuing to watch these cases as they come out. Now I'll turn it back to Kathy.
Thanks, Jen. Not sure what happened to my screen, but I don't know if you can see me. Oh, here it is. So access to medication and medical care is my next topic. I just want to say the administrative law wonk in me really appreciates what Jen was just talking to you about. And for any law students listening, this is why you should be taking administrative law. Really understanding the undercurrent of what Jen was talking about with those powers is incredibly important to the practice of any law, but definitely health law. So here, why these cases, Kathy? I picked these cases because they each address a healthcare access issue that gets at health inequities or health disparities. The first one, because the Supreme Court is hearing it, so I thought I would include this. This is a case that is pending before the Supreme Court now. What it really has to do here with is there is an employer-based healthcare plan that sets up access to HIV medications where patients, employees can get access to the medication either at a specialty pharmacy, which are frankly few and far between, or by mail. But if they just want to go to the regular pharmacy, the cost is essentially prohibitive. It's extremely expensive. And so this case presents a, kind of a hardcore legal question of whether the Rehabilitation Act or the Affordable Care Act allows for these plaintiffs, these employees, to bring a case challenging this employer health plan on the grounds that it has a disparate impact on them, and whether they can bring that claim on what is otherwise a facially neutral statute. So, it's kind of wonky, but actually could have a significant impact on, access to particularly high cost medications that are typically covered, but may be subject to lots of different hurdles for people to gain access to through their employer-based health plan. So Supreme Court's hearing that case this term, and so we'll have resolution of that question. It actually won't resolve whether these employees have been discriminated against or there's been the disparate impact. It's just allowing us to find out whether that kind of claim can be brought, and then we would have resolution of that case. The second one I want to focus on is the Rosebud Sioux Tribe case that was decided in August by our 8th Circuit Court of Appeals in the US. And it actually is pretty significant in that it really is the first time that a court has said, number one, the United States has an obligation under certain treaties, the Treaty of Fort Laramie from 1868, still is good law in this country. The obligations the US undertook vis-a-vis tribes in that treaty are still in place, emphasized further by provisions in the Snyder Act and the Indian Healthcare Improvement Act, together combined to say the United States has an obligation to provide physician-led competent healthcare for this Sioux tribe. And frankly, the decision really takes the US to task for the inadequacy of the healthcare being provided essentially through the Indian Health Services or the IHS. For comparison purposes, each person covered by the IHS received about $3,800 kind of worth of medical care, whereas folks on Medicaid receive about $8,100 per year. And so you can just see the disparity even there. Medicaid is insufficient, many of us would believe. And so if you compare that to what IHS is providing, we can see those disparities. While this does not give money to the tribe for providing medical care or to IHS, it really it reinforces that the US has this obligation and really provides advocates with a strong foundation for arguing to Congress why there should be additional funding to IHS, in particular funding for this tribe. So hopefully this can be used to eke away at the health inequities in many of our tribal communities. And then lastly, another health inequity in our prison population. And this case I thought was interesting because in Oregon, the state was allowing access to vaccines for staff, employees, correctional officers in correction facilities, and to residents and staff in other congregate care facilities in the state, but was denying that access to inmates. And so that distinction seemed to make no sense. And in fact, the federal district court in Oregon agreed with that and ordered that inmates be provided access to the COVID vaccination, frankly, there as quickly as possible, that they be placed in the same category as those other populations that I mentioned. And so to be sure, the health inequities for our incarcerated population are significant. And so this was another case kind of trying to cut against those health inequities. Now, Jen, on to the very important issue of how do we construe the statute that the federal government kind of passed in a hurry in COVID, and what does it really mean now after the fact?
Kathy, thanks for that intro. I would hate to give the general legal answer of it depends, but it depends, and it depends which court is making a decision. So Kathy is talking right here about the PrEP Act, the Public Readiness and Emergency Preparedness Act. This act has been huge during the COVID-19 pandemic. This is a federal law that provides liability protections with respect to the use of emergency countermeasures. That includes things like COVID-19 vaccinations, COVID-19 treatments, PPE, and the PrEP Act. The federal government has really used the PrEP Act throughout the COVID-19 pandemic in ways that we haven't seen it be used before. For example, in one of the amendments to the PrEP Act, the federal government essentially preempted state law with respect to pharmacist licensing and scope of practice, and said, no, pharmacists across the country get to administer the COVID-19 vaccine and are protected by the PrEP Act's liability protections in these certain circumstances. And so the PrEP Act's protections, the PrEP Act's preemption of state law and its application, these are things that are being litigated in courts right now. And the two cases that I'm going to be talking about both happened in federal court in California, and interestingly kind of point at each other. So first of all, we have Garcia versus Welltower. Here, a California federal court found that the PrEP Act provided immunity in a suit alleging elder abuse and neglect and wrongful death. Defendants in this case operated and managed a senior living facility where Gilbert Garcia lived during the COVID-19 pandemic. He had a history of heart attacks, stroke, glaucoma, and hypertension, was considered to be at extremely high risk for complications of death related to COVID-19. This suit was actually filed after he passed away. Defendants argued, though, that they were shielded from liability by the PrEP Act, which immunizes, again, those covered individuals engaged in activities related to countermeasures, medical countermeasures. So the court actually granted defendants' motion to dismiss the case in full, finding that the defendant's actions fell within the scope of the PrEP Act's immunity provisions and that it preempted that suit. Now, next slide, please. In another case in the same district, Thomas versus Centuryville, Inc., plaintiffs alleged that a nursing home caring for a patient who later died was negligent in failing to protect him from COVID-19 and other illnesses. The nursing home here claimed that the PrEP Act, its subsequent amendments, and an advisory opinion actually issued by the Federal Department of Health and Human Services blocked the state law claim. But this court disagreed. It declined to defer to the advisory opinion, and it found that the PrEP Act likely did not apply. Its analysis centered on the fact that the PrEP Act governs those emergency countermeasures, those medical countermeasures, and that the plaintiff's claims didn't implicate those countermeasures. And even if the PrEP Act applied, the court said it would not completely preclude a state law claim. So these cases certainly depend on factual analysis to determine whether a medical countermeasure is involved. But with respect to the PrEP Act and precluding a state law claim, these cases kind of point at each other. So what can we take from them? We can take from them that litigation surrounding the PrEP Act, defining the PrEP Act, shaping how the PrEP Act works, how its preemptive powers work, its interpretations and its boundaries, This is continuing to develop in real time. Appeals courts may be able to clarify this applicability. The inquiry may, continue to be that sort of fact-intensive one to determine whether covered countermeasures are involved, but that preemptive power will still be watching for cases to develop that at a higher judicial level. Now back to Kathy for some cannabis talk.
And this is way more fun than it would have been alone. So thanks for bouncing back and forth with me. And I'm sorry I made you take on those two cases. Can you explain these two cases that came to completely different solutions? So thanks. So cannabis cases, we couldn't not talk about cannabis. It's from a public health perspective, and law and policy in the cannabis realm is really developing at rapid pace, and we can barely keep up. So as a consequence, as a shameless plug, soon you will be able to sign up for what's called the Cannabis Quarterly. It's going to be a quarterly newsletter that the network puts out, produced by my colleague, Matt Swinburne, Deputy Director of the network's Eastern region. So it's going to come out quarterly. But I thought I should talk about a couple of cannabis cases that are new this year. The first being out of Mississippi. This is a state court case. And here, Mississippi voters, through voter initiative, voted 68% in favor of legalizing medical cannabis. They don't even have medical cannabis, right, in Mississippi. And the state Supreme Court overturned that pretty significant, voter-supported initiative on a technicality, but a real technicality, right? The state law that sets out the rules for how a voter initiative can prevail on the ballot had not been updated since the state went from 5 congressional representatives to 4. And so while it talked about having 20% favorable vote from each of the federal districts, there are now only 4 districts, and they never updated their constitution to say you needed 25% favorable vote from each of the 4 districts instead of 5. And so on that technicality, the court overturned this voter initiative. And to be frank, there were lots of leaders in Mississippi trying to get this voter initiative struck down. That gives you a bit of a sense of where they are politically in Mississippi on this issue. Interestingly, this puts in jeopardy about 20 years, 2 decades worth of constitutional amendments or voter initiatives that have occurred in Mississippi, because if this one is deficient, then all of those are as well. And then a more substantive case that really is a hot issue across our states, and that is whether does federal law preempt or interfere with a state court or a state administrative body ordering that an insurance company provide workers' compensation coverage for medical cannabis, if that's what a doctor has suggested would be helpful to the employee dealing with that work-related injury. And here the New Hampshire court said there is no reason that federal law preempts or interferes with that state order and allow that order to remain in effect. We did do a webinar in April of this year it's called Legal Protections to Prevent Discrimination Against Medical Cannabis Patients, talking about how state laws differ in this space. So this is a specific to New Hampshire case. If you want to know what the law is in your case on whether workers' comp covers or doesn't cover, you can watch that webinar, and we have other materials, but you can reach out to the network and we can answer for you. But this is a question we're going to see coming up time and again. And so legislative bodies are weighing in on that so that it's not going to be decided by the court. So be on the lookout for the inaugural Cannabis Quarterly. We'll take these issues up even more. Voting rights, Jen.
Thanks, Kathy. So I'm going to close my portion of our sort of topics and case analyses today with a big voting rights decision issued by the Supreme Court this past term. This case is Brnovich versus the Democratic National Committee, and it was issued on July 1st. The Supreme Court rejected challenges under the Voting Rights Act of 1965 against Arizona state voting rules that were newly passed. And I'll describe briefly what these rules did. The challenge rules provide that first, in counties that use a precinct system, in-person election day votes cast in the wrong precinct will not be counted. And second, for mail-in voting, no person other than a postal worker, an elections official, or a voter's caregiver, family member, or household member can knowingly collect an early ballot. The DNC argued that these restrictions disparately impacted Black, Native American, and Hispanic citizens, and that the ballot collecting restriction was enacted specifically with discriminatory intent. Potential public health impacts of this case are exceedingly clear. Voting influences structural determinants of health. It shapes governmental systems and resulting policies, which go on to affect individuals. And the recently published Health and Democracy Index clearly illustrates that more voting access leads to better health outcomes. That's just a fact. So the court, and next slide, please. Considering the VRA's language, the court said that the touchstone under the VRA, specifically under Section 2 of the VRA, is whether voting is equally open. Equal opportunity, they said, is not a separate requirement, but it is a means of sort of assessing openness, whether there is equal openness. And the court found that the precinct-based voting requirement imposed modest burdens, and its disparate impact was small, as measured against state interests in establishing and maintaining precinct-based voting. So it did not violate the VRA. The ballot collecting restriction similarly did not violate the VRA because the court determined that plaintiffs were unable to provide statistical evidence showing it had a disparate impact on minority voters as measured against the state's interests in preventing election fraud, intimidation, and pressure. Again, another scathing dissent. Justice Kagan, joined by Justices Breyer and Sotomayor, argued that the majority here was rewriting the broad language of the Voting Rights Act, cabining it for fear of congressional language being, quote, too radical. And the radical reading in the majority's words could potentially invalidate just about any voting rule a state adopts. Justice Kagan, though, explained that the court here is yet again rewriting in order to weaken a statute that stands as a monument to America's greatness and protects against its basest impulses. I think the significance of this case speaks for itself. This decision, which will not improve voting access and in fact results in the opposite outcome, will not help, particularly given research indicating that more voting access leads to better health outcomes. Now, with that said, I'll turn things back over to Kathy real quick.
Shockingly, I'm going to get to my last slide, which is the Second Amendment cases. I didn't know we'd get to, but we have enough time for me to quickly run through this and then get to your Q&A. So queue up those questions. I see some in there. Keep them coming. But I just wanted to highlight one Supreme Court case that is pending involving the Second Amendment, and that is to a New York statute. So in New York, in order to have a concealed carry permit, an individual has to demonstrate a special need. And these individuals who were the plaintiffs in this case were denied a concealed carry permit. They alleged a special need, and the state said, nope, we don't think that that fits within our statute's definition of special need, and the individuals have now sued. So, the Second Circuit Court of Appeals found New York's law to be constitutional, that it did not violate the Second Amendment, and the Supreme Court has agreed to hear the case this term. And so we will find out whether the Supreme Court, as I talked about reproductive justice, eked away at rights. And in this case, more likely the concern is that the court will, broaden the already broad Second Amendment rights that do threaten public health. I will say, point out that Ninth Circuit decision out of Hawaii, where similarly, Hawaii allows individuals to have open carry if they can demonstrate an urgent need to do so, et cetera. And in this case, again, an individual who didn't demonstrate that urgent need, didn't even really articulate one, was denied open carry and sued. And in this case, the Ninth Circuit found that the Second Amendment does not guarantee a right to openly carry firearms in public, which obviously is a positive public health outcome. So on that note, I'm going to turn it back over to our moderator, Morgan.
Okay, so I will kick off the Q&A with a question for Jen. So what did the Sixth Circuit decide with regard to religious exemptions to vaccine mandates? And as a follow-up, what are your predictions if the Supreme Court takes up a vaccination case addressing religious freedom?
Thanks, Morgan. So those are great questions. I'll try to be as brief as I possibly can, but there's a lot to unpack here. I would recommend seeking out the Sixth Circuit decision and the First Circuit decision if you're interested. I'll tell you the names of both of those cases. First, the Sixth Circuit is Dahl versus the Board of Trustees of Western Michigan University. In this case, the university required that defendants who were sports athletes had to obtain COVID-19 vaccination in order to participate on a college soccer team. And what ended up happening is that requested religious exemptions had been rejected, were rejected. And the Sixth Circuit agreed with the lower court in this case when they looked at what they're looking at specifically is for this to be kind of a constitutional violation of the free exercise clause, we have to look at whether this is a neutral and generally applicable restriction. And if it's neutral and generally applicable, then only rational basis scrutiny will apply. But if it's not neutral, it's not generally applicable, then we have to apply strict scrutiny, which normally things will fail, laws will fail, mandates will fail strict scrutiny because it is a very high bar. In the Sixth Circuit case, the court determined that it was not neutral, it was not generally applicable, it could not satisfy strict scrutiny. But very fact-specific analysis here as to what is neutral and what is generally applicable, which should be contrasted with the First Circuit's recent decision, and that is a decision involving Jane Doe's. I'm going to just quickly see if I can, Jane Doe's 1 through 6 versus Mills. And that case concerned Maine's healthcare worker mandate, whether there's a religious, whether there needs to be a religious exemption. In that case, it was neutral, it was generally applicable, rational basis scrutiny applied. And the First Circuit actually does a really great job of distinguishing that Sixth Circuit decision. So I would highly recommend taking a look at both of those. Now, when it comes to the Supreme Court, they have not entered yet, but I predict that they will. I think it's very, very likely that they will. The Supreme Court issued 3 cases in the last term: Roman Catholic Diocese versus Cuomo, South Bay United Pentecostal Church versus Newsom, and Tandon versus Newsom. The South Bay is not the 2020 decision, it's the 2021. It was the second one. And in these decisions, the court assessed religious freedom arguments to COVID-19 social distancing measures. And in each of these cases, the court systematically upheld religious objections over the public health measures. And truth be told, did not do a very great job of explaining the analysis or explaining where it was coming from with that analysis. Suffice it to say that the court declined to apply that neutral and generally applicable framework. In a more recent case, the court has indicated doubts about whether it even still wants to keep that framework alive. So I think it's highly likely, if a religious freedom argument comes with respect to vaccine mandates after all of the merits have been resolved in the lower court cases, the Supreme Court could certainly take it on and carve that out.
Thanks, Jen. And now a question for Kathy. So what would you say we have a lot of abortion cases going on and a lot of, abortion precedent already. So if Roe versus Wade, which is the right to pre-viability abortion, and Planned Parenthood versus Casey, which sets the undue burden and substantial obstacle test, are still good law, why do states continue to pass laws that seem to counter those cases? And how may the Supreme Court change longstanding case law?
Yeah, fabulous question, because we've learned, right, in our even just American history or, American government classes and definitely in law school that there's this thing called stare decisis, right, precedent, and the court has to follow what it said before. And yet, obviously, over time, we know there are cases that the Supreme Court has overturned. I mean, Brown versus Board of Education was overturning very bad law that said separate but equal was okay, right? And so sometimes the court overturning its own case law is a good thing. But here, the right to abortion has been slowly, eked away to some extent over time. But there's been, maybe jurisprudence defining what it really means, the Casey case that you referenced. But the reality is the makeup of the court is different. And there have been, there are states in this country, legislative bodies, governors, and constituencies that are highly interested in having Roe versus Wade overturned. And they pass these laws so that they can get into court and see if they can convince the court to overturn or severely curtail the rights provided in Roe versus Wade. And that's what Texas did here. I mean, Texas intentionally created a law that they know, there's no one who could look at this and say this doesn't contravene the rights that are set out in Roe versus Wade and the cases that come from that. They want that direct question to be presented to the court. They're not even hiding that in their briefs. In this case, in this preliminary phase, they're saying that we want you to overturn Roe versus Wade. So that's why they're doing it. The question is whether and to what extent it will be successful, before the court.
Right. Well,
that's the question I won't answer.
And on a different topic, I know we got a couple abortion and vaccine, just to kind of spread the love amongst topics. I've noticed, and we got a question in the chat similar, the Supreme Court and Congress both seem very disinterested in cannabis cases and legislation. So why do you think that the federal government hasn't just, released cannabis into the Controlled Substance Act and not have that as a Schedule I drug, and kind of leaving regulation to the states?
Yeah, to be sure, in some ways, functionally, Congress has done that, right? Or the federal government has done that through not enforcing, provisions of federal law in states that are operating well-run, well-operated, well-enforced, at least at this point, definitely medical cannabis laws and, increasingly adult use cannabis laws. So while Congress hasn't passed a law descheduling or differently scheduling cannabis within the Controlled Substances Act, the federal government for some time now, for, I'm going to say near a decade, has said, we are not going to come into states that are operating, again, a proper program, one that was passed by the legislature, has regulatory provisions, has enforcement provisions, and people are operating within that. We're not going to come in and be engaged. I think that one of the difficulties is, what does Congress do in this case? Do they simply take cannabis out of the CSA? And then what happens in states that don't have a regulatory system? And so I don't know that that's a palatable option. Then you get into the option of now Congress has to actually have a lot of substance in whatever it's going to do with Congress. And they just haven't had the interest, attention span, desire to engage in kind of the hard question answering with how they will regulate the product that will, again, allow the state programs to exist, but have some federal regulatory scheme in place where there aren't state schemes.
Thank you, Kathy. And it looks like we have time for one more question, which Kathy or Jen, feel free. A question in the chat mentioned there being a rise in failure to protect type cases, particularly in the context of school masks. For example, in Wisconsin and in Colorado, against school districts and public health agencies who fail to issue mask orders or other protective measures. Do you see this as a growing trend?
I'll jump in, Morgan.
Yeah.
Yes, absolutely. And this is sort of the point that I was trying to get across with respect to the Arizona case, but I want to make it more clear now that there are a variety of different arguments going on to challenge those laws, to challenge those limitations, to challenge bans on mask mandates. So there are several lawsuits going on right now saying that banning mask mandates violates the Americans with Disabilities Act, violates rights for children with disabilities to get an equal education. But there have also been cases, like a case in Arkansas, where a mask mandate ban law was actually overturned by a county judge on equal protection grounds because this law applied to public schools and did not apply to private schools. And so there was really no rational basis to distinguish between the one and the other. So the court found the law unconstitutional under the Arkansas Constitution for that reason, among others. So yes, that is a trend that is starting to pick up speed, and the arguments are varied.
Thank you, Jen. Well, we are quickly approaching or at the end of the hour, and I want to be mindful of everyone's time. Thank you all for attending, and thank you to our great speakers for their insight. And I will pass the torch to Charles to finish us off. Thank you.
Thanks, Morgan, and thank you everyone for your participation today. Just a few final notes. All attendees will be receiving an email from the network with the video playback of this session, as well as our brief webinar survey. And the survey takes just 1 minute to complete and provides us with some really great insights. You'll also be receiving an email from ASLME with information on how to apply for CLE credits for this event. And finally, join us next month for a webinar on the new Climate Change, Health Equity, and Public Health Law Learning and Practice Collaborative. You can learn about that webinar and register for it by going to networkforphl.org/webinars. And that concludes today's session. So thank you all for attending and have a great rest of your day.